thank you for coming. My name is Linda from Somerset Escrow, and we're bringing you this information. We're starting to call this sessions Agent Leverage Lunch, because I think you learning gives you the leverage to be able to speak to your clients in a way that no other client can, because your guys are getting educated. And I think that will set you apart from other agents, and that's our goal with our company, is to educate. We are brokers ourselves, though we usually are 90% wearing our escrow owner hat. We own 2 escrow companies. The one we're promoting here is Somerset Escrow in Claremont, Upland. I know a lot of people say, oh, you're not in the area, but I don't have to be in the area. Everything gets online. I have notaries. If you do have someone that needs like physical to go to their house, my escrow officers go, and they help them out. So we understand that. It's a lot of baby boomer owners that we deal with, so we're well aware of that. And with that said, I want to introduce our co-sponsor, Michelle.
I'm Michelle. Welcome. Thank you all for coming. We hope that this is something of value. We've got 2 great speakers today, so we just really want to promote them and educate you all. So thank you for coming.
Yes.
So today's speaker is Kent Meyers with Assessors Protection Network. He is fantastic in the intricacies of assessing. So he has a broad range of knowledge, and I hope you get a lot out of this talk. And once again, I'm Hector Gutierrez. I'm her other half. And so a little bit something about our company. Somerset Escrow has been a settlement service provider for over 35 years. And we bring to every transaction security, experience, but most of all care. Because we know by the time it comes to our office, how much time and effort you have all put into it. So we appreciate that, and we're gonna do our absolute 1000% that we have a successful transaction. So without any further delay, Kent Meyers.
So has anybody heard me speak before? Okay. So my background, I worked for an assessor's office for a little over 16 years. I became what's called a property tax agent about 9 years ago. Property tax agent is somebody who works for the property owner and tries to fight the assessor due to overvaluation of their property or erroneous changes of ownership. Have any of you ever dealt with the assessor before? Okay, there's some head nodding going on. Oh, yeah, it's a scary feeling. And you don't know. Well, I speak their language, so I know what to ask. And I know when they're giving me a runaround. And I know when they're giving me just a full line of bull crap. And usually when they start telling me things and telling me why I have to do certain things, I'll say, well, are you familiar with the Revenue and Taxation Code? Are you familiar with this section of the R&T Code? And they usually respond with what? The Revenue and Taxation Code is what sets the assessor up for everything that they have to do. They're required to reassess property when there is a change of ownership or when there's new construction. Everybody here a realtor? Okay. You guys are familiar with the most common change of ownership, which is when somebody goes out and buys a house. The assessor has to establish what the value, fair market value of the house is when they purchase it, and that becomes the new tax base. Some of you may have heard this before. The assessor is required to accept your purchase price. Anybody hear that before? That's not true. They're required to enroll fair market value. 99% of the time, the purchase price is fair market value. But if it's not listed on the open market, or if there's collusion between the individuals that are buying and selling, the assessor can say, wait a minute, this sales price is outside of range. And we're going to enroll what we think is fair market value. I'll give an example of one that I worked on very early in my career. It was only like a $400,000 sale, maybe $300,000, I don't remember what it was. But it sold for about $70,000 below market. And we didn't have access in the assessor's office to MLS. So I called the buyer and asked him why he paid so much less than what was typical in the marketplace. And he asked me, well, who are you? I said, I'm with the assessor's office. I'm required to enroll fair market value, and this is below market. He said, well, maybe I should talk to my attorney. And I said, you have every right to talk to your attorney, but I am obligated to enroll fair market value. If you don't give me any good reason why you paid below market, then I'm going to enroll what I think is fair market. I'm going to talk to my attorney. Okay, I enrolled fair market value. They get a notice. That notice gets to them, and they look at the value that's on there, and they call me right away. Say, listen, the house was in disrepair. The realtor would not even go inside. So I said, send me the listing, send me the cost of repair, show me some photos, and I can change this. And that's what they did. But if they just spoken to me originally, then we might have been able to get that result without a huge issue.
But what prompted you to check more in detail when the purchase price has already been recorded, right?
Mm-hmm.
So what prompted you to think, oh, you know, this
Well, the assessor is required to enroll values on every sale. And we take a good look at all the sales and say, well, what's the common sale in that area? What's the common sales price for this square footage? And if something stands out, then we go, okay, there's something wrong here. Now the assessor has more access to MLS, so they can look online and go, oh, there's a major disrepair. So they can look at it from that standpoint.
The assessor also reassess after the new owner remodels, correct? Because I've seen that happen.
That happens sometimes. It depends on the situation. Section of the Revenue and Taxation Code allows you to remodel your home or do repairs, and as long as you're maintaining market value, they should not do any additional reassessment. If you're doing something major, if you're buying it in a disrepaired state where it's not inhabitable, I mean, I've walked through homes that didn't have toilets and didn't have any of the kitchen appliances or countertops. That's a huge remodel. And yes, the assessor has the right to reassess for that additional interior remodel. But you don't see it very often, and the reason you don't see it very often is because the assessor's too dang busy. Okay? So right now, I don't know, does anybody here own property in Ventura County? Orange County? Orange County? Did you get a value notice recently? Okay. Orange County, San Diego County, Ventura, San Francisco, and about 8 other counties send out a value notice about this time every year. And the value notice, once it gets to you, it's your annual notice saying what the value of your property is for property tax purposes. From the time you get that notice, you have 60 days to file an appeal if you disagree with the value. The non-notice counties, they don't send you a notice this time of year. They wait until your tax bill comes out in October. In those counties, you have until November 30th to file an appeal on your annual assessment. So let's say, like, how many of you were selling real estate back in 2007, 8, 9, and 12, 13, 14? Okay, what was the difference in values 7 and 8 versus 12? And okay, yeah. So let's assume for a moment you get a value notice in 2012 and you bought your home in 2007. And the value in 2007 was much higher than 2012. So the value that you get on your notice and or your tax bill is based on January 1st of each year. So if you never really paid attention to your value notice until 2012, you go, wait a minute, my value's not that high. You have until, if you get a notice, you have until September 15th to file an appeal. If you don't get a notice, you get your tax bill. You have until November 30th to try to challenge that value. It's a 1-year valuation. So it's January 1st of each year is what the value's based on, and of what the value is on your bill is higher than what your January 1st value was. You can file an appeal and try to get that reduced. And if you're successful, it's called a decline in value, and it's temporary. But once you go into the decline in value status, the assessor is supposed to review you annually until the market goes back. So an example, personal, I sold a condominium in late 2005, $460,000. Okay? By 2012, it was only worth $160,000. Now, the people that bought it from me, they got foreclosed on, and the bank sold it for $330,000 a couple years later. A couple years after that, it got foreclosed on again and sold for about $220, but at the bottom it was $160. $460 down to $160. Since 2012, it's steadily been going up. As you all know, during COVID, it went up a lot. You know, I had a friend that was trying to buy a $1.5 million home during COVID. It was listed at 1.5 and it sold for 2.2 because interest rates were 1.5%, 2%. But in that situation, where that $460,000 that the people had held onto their property, the value of $460,000 was not retaken until 2020. So from 2005 to 2020, the value did not increase. It was just a straight flat line. But the assessed value, the base value, it goes up 2% per year. So in that 15-year period, you're looking at about a 40% increase. When you factor 2% times 2% times 2%. So you've got a situation where by 2020, that $460,000 is about 20% higher. About 40% higher than what they paid for it as far as a maximum assessable value, but it was only worth $460 in 2020. So that's what you have to look at, okay? Other issues, again, with your sale, that's the most common instance where you're going to have a change of ownership that you're going to be reassessed on. New construction. If you're doing like an addition, adding a garage conversion, all of those are new construction and they're reassessable. Let's assume for a moment you've owned your house for 20 years and you bought it back in, let's say 30 years, mid-90s. Mid-90s, bottom of the market again. So you owned your home since the 1990s, mid-90s. You have a very low base value. It still goes up 2% per year, but it's not anywhere near what the current market is. And you do a 300 or 400 square foot addition. The assessor is allowed to pick up the fair market value of the addition only. They cannot revalue your land. They cannot revalue the original structure. They can only add value for that new construction. So you'll actually have multiple base years on your property. You have a base year value based on your original purchase, and you have a base value on your addition.
So, a lot of people are converting their garages into ADUs and it's allowable. So what's the tax base, and then do they subtract that, you get rid of your garage, and then with the taxes, do they take that, they discount that, and then they add the value to the ADU?
If you're demolishing your garage,
They not demolish it, just like
if they demolish the garage, then they have to remove the value of the garage and then pick up the value of the ADU. If they're doing a garage conversion, the garage structure is still there, and they have what they call a conversion formula or cost, and they just add that, they figure out the square footage, the quality of the new construction, and add that difference in value. And then your conversion has its own base value also. Answer your question? Okay. Any other questions about construction? I'll give you an example. Go ahead, Hector.
So I just want to be clear. So if I am putting a new roof in my building and basically the assessor, well, not the assessor, usually when you fill out the documents, it says what's the valuation on the roof for $20,000, $30,000. That shouldn't trigger any new assessments on the current valuation.
That should not.
Okay.
Because a roof is required for the building to exist, or be used, I should say. So if you do take out a permit to replace your roof, that's standard maintenance. It's just repair of existing, maintaining your current market value. So yeah, your market value will go up because you're fixing your roof, but you're just maintaining the market value compared to the rest of the neighborhood. So that is not a reassessable event.
I have a question, like, if the person bought the property on the record, assessor sets 1900. But when the appraiser came in, and then they actually measured at 2300. So for the new owner, in order to correct that square footage data on the assessor, so he has to go to the assessor office and then give them the information, everything that the owner had done, had permits. So the assessor office would send someone to the actual property to measure it. But then I realized when they measure it, they don't measure inside. They measure the outside of the home. So
Typically.
Yeah? Why?
Yeah, typically.
Yeah.
If there's a second floor, they'll go upstairs and measure the interior sometimes. But usually you're looking at, if it's a single-story home, they just measure the exteriors, figure out what the garage is, and they're done. Okay?
And then because the key is they want to change to the exact measurement, so that in the future, when they sell, it's,
Yes.
it's-
And in that situation, I don't know if you guys ever sold a property that had some illegal construction on it, or unpermitted construction, or possibly permitted construction that the assessor didn't pick up. In those situations, okay, buyer comes in and they buy it as is. They do due diligence or they don't do due diligence, and they find out that there's illegal construction, but they buy it anyway. They're purchasing the property with that illegal construction. They're purchasing that property with the addition, maybe, that is permitted. The assessor, if they accept the purchase price, they're going to know that addition is there or not. I get calls every now and then saying, hey, my records are incorrect. Okay. The previous owner took out permits 30 years ago. Well, building and safety in most counties in California didn't even exist before 1948. So in those instances, a lot of people did new construction without permits because they weren't required. So if they did an addition in the 1940s, it may not be on the record. But what building and safety will often do, they do not have access to the assessor's records. Permits are public information. Assessor's records are not. So when I worked for Ventura County, people would be worried about their additions that may or may not be legal, and they would go to building and safety, and building and safety would walk with the owner to the assessor's office, and the owner would ask for the building record that the assessor has. They open it up and say, oh yeah, we have this addition. It was built in 1963. And we even have a permit number. In Ventura County, building and safety burnt down in the 70s. So they don't have a lot of permits pre-1970s. But building and safety go, oh, okay. And they'd go ahead and just grandfather it in if it was on the assessor's records, even if it was an illegal structure. Today, a lot of municipalities won't do that. They will require, if they discover it, you to go out and get a permit. It's easier than, just to get a permit and get it legalized than it is to actually build it, right? But the assessor should update their records and include it in your sales price, and therefore you should not get reassessed when you're just legalizing a structure that existed when you bought the property. I'll give you an example of a case that I had. Person owned a home in Beverly Hills. They converted their garage to living area and added a carport. And the assessor added $770,000 for this converted garage, since you brought up conversions. We challenged it. I actually knew the guy that handled all their cost guides at the time, and I called him directly and asked him some information. And when I told him what it was, he started spitting and sputtering, going, what the hell, was it gold laced? So he gave me all their cost guides, and we went to appeals, and we got it reduced to $330,000. That's a substantial reduction. That's about $5,000 a year in property taxes. Another example, somebody bought a house, Beverly Hills, $5 million. What's the first thing somebody in the very wealthy neighborhoods does when they buy a house?
Remodel.
There you go. So they had
Trees out,
yeah. They had $1 million budget to redo their house. They wanted to redo the kitchen, of course, the flooring, the master bedroom and bath. That's the typical things that people do when they buy their own home, is do these remodels. When they tore open the kitchen, they found bootleg construction. They were like the fourth or fifth owner, so they couldn't point and say, hey, that's the guy that did it. So there was no lawsuit there because nobody knew about it. And it cost them an extra $1 million to fix. Okay. We filed an appeal. The argument was they would not have paid $5 million for this house if they had known about this bootleg construction. We got it reduced to about $4.1 million, saving him about $10,500 a year in property taxes. And they did not add value for the remodel. So.
So the reassessment is not just based on the addition of the square footage, but also the interior modeling? Is that what
They
you're
can
saying?
pick up value for interior remodel if they choose to, if they can prove that you're doing something beyond market. I mean, it's hard for the assessor to prove that. So they usually don't even pick that up. Now, change of ownerships. The most typical change of ownership, as we discussed, was when you go out and buy a house or buy a commercial property or apartment building, whatever. The second most, or I should say the first most common erroneous reassessment, and we're going to have a discussion about that, or a presentation about that in a few minutes, is when people transfer their property into a trust. What happens is they change title, and they should check off their preliminary change of ownership report. Does everybody know what that is? Okay. That it's just a transfer into their trust. The assessor will often require a copy of the trust. If they don't respond, they get reassessed.
Wow.
Oh, yeah.
Is this a new thing?
Oh, no, it's been going on for decades. Depending on the county, you can get that reversed very quickly. But LA County, that's another story. LA County, sometimes they'll do it right away. It depends on how far they are in the process and how soon you've contacted them after getting the reassessment notice. If you didn't contact them within 60 days, they will obviously file an appeal. I don't want to deal with you. Yeah, that's a great look. But that's what they do. I recently had an attorney refer somebody to me. It was about a year and a half ago. They got reassessed in 2019. Their taxes jumped $2,500 a year. Yeah, and because they transferred to a trust and they didn't do anything about it, so they called me finally, and we got that reversed, and he got 4 years worth of refunds. Only 4. It happened in 19. We just got the reversal last year. They adjusted the 2024 tax bill, gave him refunds for 3, 2, 1, and 0, but not 19. Statute of limitations is 4 years on refunds. Okay. But he also told me that he had a friend, and he wanted his friend to give me a call. His friend called me. Same year, actually about 6 months earlier, so carried into 2018, he got reassessed when he transferred into a trust. His taxes, his property was assessed at 1.5 and it jumped to 4 million. $30,000 a year in extra property taxes. And he didn't do anything for 6 years. So we got the 24 adjusted, 3, 2, 1, and 0 refunded, but 19 and 18 were not refunded. But they paid him interest on the years that he was overassessed for. He just got checks last week for $166,000. But that's $166,000, but that's another $60,000 that he did not get refunds for. Kind of sucks. Okay. Want to talk about Prop 19? Oh, you have a question.
Yeah. So one of my clients closed out downstairs bedroom suite.
I'm sorry.
One of my clients closed out one downstairs suite, and he changed the window to a door. Now the square footage didn't change, but they have a separate entrance suite. Would that trigger?
Did they add a kitchen or a bathroom?
No.
Okay. If they did not add a kitchen or a bathroom, they shouldn't get reassessed on something like that. I don't think it would add that much value, if any. Let's see, what else can we talk about? Prop 19, parent-child exclusions. Prior to Prop 19 passing, the parent-child exclusion was substantially different than it is now. Parent-child exclusion now is if the parents pass away or sell their property to their children and it's their primary residence and the children moves in within 1 year, they can qualify for a parent-child exclusion. But the exclusion is not from reassessment, it's from taxable value. They call it an exclusion, but it really isn't. An exclusion means you will not be reassessed. But they do reassess the property at fair market value upon the death of the parent or the transfer of the property to the child. And they use fair market value. So here's a simple example. Let's say the house is worth $1.1 million and it's assessed at $300,000. The difference is $800,000. So they transfer to the child, the primary residence, the child moves in, file their homeowner's exemption form, and they will reduce the value down to that $300,000. You don't get the full $1 million exclusion because the difference, the most they'll take off is what your parents were paying. But if you have a home that's worth 2.5 and you're assessed at $300,000, you move in, fair market value is 2.5 million. Your new taxes will be 1.5 million, or based on 1.5 million, because that's 1 million off fair market value. So you don't even get close to that 300,000. So you're not keeping your parents' old base value. So the three requirements are: one, it must be your parents' primary residence. Two, the child must move into the property. And three, and there's four requirements, I'm sorry. Three, they must file their homeowner's exemption within 1 year. If you don't file the homeowner's exemption within that 1 year period, you can still file it, but it becomes prospective. So let's say you file it 3 years after you move in, but you did move in within 1 year. You're not going to get refund on those prior year's taxes. You'll get refund starting with the year that you filed your homeowner's exemption. And you also have to file your parent-child exclusion form. You have 3 years to file that. But if you don't file it within 3 years, it also becomes prospective. So make sure you file your homeowner's exemption within 1 year. Make sure you move in within 1 year in order to get that roughly $11,000 in taxes reduced. Prop 19 also has, you have to deal with base value transfers for people over 55. Prior to Prop 19, it was much more restrictive. You could do it once in a lifetime. And if you sold your home for $1 million, you could buy a replacement for $1,050,000 or less if you did it within a year. If you did it within 2 years, you could buy a replacement property for $1,100,000 or less. Under the new tax laws, if you sell your home for $1 million, it doesn't matter what you pay on your replacement property. The difference in your sales price and your new purchase price gets added if you pay more. So let's say you sell your home for $1.2 million and you buy a replacement for $1.5, you were assessed at $400. You take your $400 to the other property, plus the difference between your sales price and your purchase price, $300,000. So your new tax base on the new property is $700,000. Think about that the opposite way also. 1.5 million is sales price. 1.2 million is your purchase price. There's a $300,000 leeway. Now you don't get, and let's say you were assessed at $400,000. So you take that $400,000 to the new property, but you overpaid on the new property. I'm sorry, there's a $300,000 difference between what you sold your property for and what you bought the new one for, 1.2 million. What a lot of people aren't aware of is a construction credit. That $300,000 less that you paid for the house can be utilized as a construction credit within 2 years of selling the original, where you can build a swimming pool, an addition, an ADU. They won't add anything. Yes. So that's the new construction credit. If you sell for more than what you buy your replacement for, you get a new construction credit, but it must be used within that 2 year period. Already answered your question? God, I'm good.
Wait 2 years after you bought it, you have to use this. Otherwise, after 2 years.
After 2 years, it's null and void.
You cannot use it.
He's got a question.
So I think this question also ties into the question I had before we talked about Prop 19 is, does the reassessment in general get, whenever you do new construction or add value, is it based on how much you spend or the value you added? It's the value you're adding, right?
Okay, he's asking, is it the market value of the new construction or the cost of the new construction that's important?
Like
Yeah, okay, well, that's a fire issue, calamity issue, so that's a little bit different.
It's the empty lot.
So just in general, if you're doing new construction, LA County is really good with this. They can do either fair market value or they can use costs. In LA County, they use whichever's higher. Oh no, they use whichever's higher, okay? An example of that, I had a client that lived out by UCLA Medical Center. He was a doctor, and he bought a home in 2009. He demolished it in 2015. 2,000 square foot, 1950s built home. Tore it down and built a 3,600 square foot brand new home in 2015-16, okay? So he added 1,600 square feet, and it's a brand new house. The assessor added 1.3 million. His cost was about $600,000, $700,000. I think it was right around 700,000 bucks. We fought the assessor, and you can do what's called a pre and post. A pre and post means you determine what the value of the property was before the new construction occurred, and then you determine what the fair market value of the property is after the new construction is complete. And from that, you say, okay, the difference between the two is how much that new construction is worth. And they didn't do that. Okay. I was able to prove successfully in front of the board that the difference between a 1950s built home of 2,000 square feet in that neighborhood versus a 3,600 square foot brand new home, because there were a lot of them going in at that time, was only about $700,000 difference. It was weird, but we got right down to about his cost. And it saved him quite a bit of money per year on taxes. So the other thing you were bringing up, Altadena and the fires. Under a calamity claim form, when the fires happen and you lose your house to a fire, the assessor is required to do a pre and post. They determine what your fair market value was the day before the fire and what the fair market value was the day after the fire. It's hard to do that with land, because when the fire comes through, the house is gone, but the land is still there. How much value did you lose in the land? Not much. But there's a stigma. There's a stigma that they should take into account also. But bottom line is they have to take that improvement off completely. And in LA County, they did reduce the value of the land as a stigma. You have 1 year to file your calamity claim form, and what that does is it protects you from your base value increasing when you rebuild. So let's say you have a 2,000 square foot home and it burns down, and you were assessed at, say, $400,000, and there was 250 on land, 150 on the house. And they take out that 150 and then they reduce the land because of some stigma. When you rebuild, as long as you stay at that 2,000 square foot level, then you get to keep your old base value.
What if you add a little bit more square?
If you add more square footage, they only pick up that additional square footage.
What if it's a new owner? What if it's a new owner?
Calamity claims do not transfer to new owners. So if as what is typical in most burn areas, I'm from Ventura County, we have burn areas all the time. So if somebody's house burns down, they collect their insurance money and then they sell the vacant lot. The new owner gets a new base value on his land. Then they rebuild a house on the property. They get a different base value and base year on that new construction. And then moving forward, they turn around and sell it, and that person gets a new base value. And there's an allocation between land and improvement. Questions about that? I have a client, I don't know the answer to it yet. Gentleman's house burned down in the Palisades. 1 week later, he died. So the daughter was the trustee on title. So she filed the calamity claim form. They got the reduction, but the question now is whether or not it'll still qualify as a parent-child transfer since there is no home on the property, and whether or not when she rebuilds, if she gets to retain the base value. And the answer is that's clearly no to me, because they have to value it at fair market value as of the transfer date.
That's very
Yeah.
unfortunate.
How many of you have ever listed a home or sold a home that was in the name of a trust where the original trustors were deceased? A bunch of you. Okay. So I get a lot of these cases. This is what happens. Somebody dies. They own the property. They held it in trust. The kids are often named as the trustees. The kids might go to an attorney. They might not. They might just call an attorney and say, hey, my parents died. The property was in trust. What do I have to do? They might talk to a friend. For some reason, a lot of people that don't know anything about trusts and ownership think if they leave it in the trust, they'll never get reassessed. Revenue Taxation Code states that when property is held in a trust, when the trust becomes irrevocable, the property is reassessable. So upon the death of the owners, the trust becomes irrevocable, and you should get reassessed. You have 150 days to notify the assessor of the death of a property owner. I haven't seen any penalties issued for not doing it, but let's talk about statutes of limitations, because I get a lot of this. What happens to individuals is this. They sell the property in the name of their parents' trust, they sign the deed as the trustee, and they go on their merry way. The assessor gets the deed, and they see, hey, this trustee is not one of the original trustors. Then they search death records, and they find out when the parents died. There's no statute of limitations on the amount of time that goes by for the assessor to reassess a property. They must reassess the property when there is a change of ownership. So I got one right now. Grandma died in 1990. She held the property in her own name. When she died, it passed to daughter and granddaughter, but they never changed title. Oh yeah, mom died in 2015. I need a probate attorney. Yeah, okay. But they should have been reassessed in 1990, but the mother could have qualified for the parent-child exclusion, the granddaughter could not have. But then when mom dies, the granddaughter can qualify for the parent-child exclusion. But there's definitely some reassessment in the past that should get reassessed. They have to file parent-child exclusion forms. And there will be no reassessment, and that $1 million reduction, that's not applicable because it's the date that they died that's applicable. But going back to the people that sell the property out of the trust after the parents have died, and let's say it happened in 2000, the assessor is required to reassess the property in the year 2000 and do all the 2% factoring. If they were notified and they just missed it somehow, they'll send out 4 years worth of tax bills. If it was not reported, 8 years worth of tax bills. If it were a legal entity that owned the property and they discovered it, then there's no limit. I'm working with somebody right now, 80 properties, held in LLCs that they transferred to kids and grandkids right after they transferred to the LLCs, should have been reassessed in 2012, all of them, and they weren't. So I'm gonna have to try to figure out what their tax liability is on that. But think about it. When the trustee sells the property, usually it's the children sell the property and they don't give a forwarding address. And they were receiving mail, tax bills at the old address, the parents' address. Well, those notices are going to go to the parents' address also, whether it be 4 years or 8 years worth of tax bills. And you have 6 months to file your parent-child exclusion from the time that they actually send out the notices. You have 60 days to file on the value. And if you did not inform the assessor of where the proper address is to mail those tax bills and tax notices, you're out of luck because it's based on the last known address for the assessor. So that's why you have to inform the assessor within 150 days so they know where to send tax bills. Okay. Let's assume for a moment you take out a permit for a new addition, or you buy a house, or you transfer your house to your children, and you change title, or you get a permit. Okay, so all that is kosher. Permits, those are supposed to be sent to the assessor by building and safety. When you record a document, you're supposed to include a preliminary change of ownership report, and that's notification to the assessor. If the assessor misses it, and 20 years goes by and they discover it, they were properly notified. So they have to go back to the year of the transfer, figure out what the value is, and what every subsequent year value would be based on the 2% increases per year. But the county can only issue 4 years worth of tax bills.
So they can only get you for 4 years if they missed it?
Yes. They have to reassess as of the date of the event, but they can only issue 4 years of tax bills. If you do not inform them, illegal construction, or you don't record a deed, or don't notify the assessor of the death of the owner, 8 years. Okay. So we have a trust attorney here. I want to ask you a question. You understand equalization of distribution of assets and equalization? Okay. Anybody else here understand it? Let's assume for a moment you have three children, and your parents' trust, or their parents' trust, says to distribute the properties or the estate into 3 equal shares. Most commonly, the only asset parents have is their primary residence. They might have a 401k and some savings, but for the most part, the home they live in is usually their only asset. And one of the children wants to keep the house and qualify for the parent-child exclusion. You have to equalize the distribution. So if you have 3 kids and one kid buys the other 2 out, it's 66% reassessable, and you lose 66% of the parent-child exclusion. So what you typically have to do, and Michelle, you might know a little bit about this, you have to get a loan in the name of the trust. Wells Fargo, Bank of America, Citibank, they do not loan money to irrevocable trusts. So you often have to go to a third-party financier, and you get what's called a bridge loan. So you get this third-party loan, and let's say the house is worth $1.2 million. 2/3 of that, $800,000. So you get a loan for $800,000 in the name of the trust, and put $800,000 into the trust bank account. Then the trustee distributes the assets. $400,000 to one child, $400,000 to another child. The third child gets the house and $800,000 worth of debt. So everybody has a gain of $400,000. It's called equalizing the distribution. That's priceless.
How many people we talk to though that have that situation? I have somebody in Monrovia right now where a brother's living there and the sister's a trustee, and it's a whole thing.
Oh yeah,
Okay,
we're not getting into family fights because.
It's just interesting when you say it that way.
Yeah.
I think a lot of people think they're just gonna I'm just gonna take the house and then,
So what happens is they get that third-party loan, and with points and fees, the last customer I helped with one of those, $20,000 in loan fees and such in order to get that third-party loan. And generally it's a short-term loan. So then after they assume the debt on the property, they go out to Wells Fargo, Bank of America, call Michelle, and they get a typical loan, but then they're paying loan fees again. Do you know the way around it? Yeah. ROFL. What's that mean? Rolling on floor laughing, right? Okay. You call the assessor and you want to talk to him about valuation, say, I just looked my value up on Zillow. That's what they're going to do. They're going to roll on the floor laughing. But actually, it's an ROFR, right of first refusal, or first right of refusal. F-R-O-R. If you have a right of first refusal, right, or first right of refusal written into your trust that allows one of the children to purchase the property, and you can do it in any way you want. Let's say when you write the trust, one of the children wants to keep the house and you already know that, you say, okay, that child will have right of first refusal. Or you can just write it in saying any of my children have right of first refusal to purchase the home. If they have the right of first refusal, they can actually buy the property after you're deceased from the trust and get the parent-child exclusion and not have to do that third-party loan. Does that add any value to you? Yeah. So if you have that written into the trust, the child can go to Citibank or Bank of America or any loan broker and go ahead and get a loan, buy the property, but they still have to pay the fair market value. They can't offset it with the amount that they're going to get from the estate. So let's say it's worth 1.2 million, they're going to get 400,000. They can't just get a loan for 800 and buy it from the trust. They have to get the full loan for 1.2 million minus whatever the bank expects them to put down. Then that money, their down payment plus the loan, goes to the trust bank account. They get title to the property and they're saddled with a loan. Then the trust estate goes ahead and distributes the cash to all three children, including the one that bought the house. But then they qualify for the parent-child exclusion. Sorry, didn't mean to spit. So then they will qualify for the parent-child exclusion and not have to worry about that.
So just a quick question. So the person that's getting the trust is getting the loan, and they're funding that trust in order to have equal shares for the rest of the trustees. But the person can also come in with straight hard cash and just fund the loan through their own means, right?
Well, okay, if you're talking about using the first right of refusal, yeah, they can do that. But if they are going to supply cash to the estate to cover the distribution, the one that is receiving the house cannot fund the trust. Otherwise, they won't qualify. One of the other siblings could do it, but they have to get a promissory note, issue it to the trust, and they have to get that promissory note actually recorded. No, we don't go backwards.
Okay, so as a new homeowner, the buyers, they bought a house and there's a ADU, which is probably brand new, maybe 2 years ago. And the seller did not have any permits. Should this new owner report? What's going to happen?
Okay, my opinion is, yeah, they should go ahead and get it legalized because most cities have a grandfather clause and an amnesty clause because the state wants people to have second dwellings on their properties now because of the housing shortage. So I always advocate for people to actually go to building and safety and talk about, hey, I just bought this house, it's got an ADU, I want to legalize it. I don't know what the fees are to legalize an ADU, 10 to 20,000 bucks, I'm going to guess. But it's advisable to do it. That way you get the monkey off your back. I'm sorry?
You said 10 to 20,000 would cost the new homeowner to make.
To legalize it, I think so, but I'm not sure.
See if the buyer did not do anything, just leave it.
They'd have to be able to prove that it was there when they bought it. Otherwise, in that case, the assessor could add value when it gets discovered, saying, well, you have to be able to prove that it was here when you bought it. Sometimes it'll be in the MLS listing, sometimes not.
And say 5 years later, city discovered that. Would the worst case, the new homeowner have to pay a fine for the?
Because you have to get the permit. You have to have an architect come out. You have to have building and safety come out to inspect to make sure that it's to code. So yeah, there's going to be some fees involved and some costs. And my $10,000 to $20,000 might be low. Yeah, you're shaking your head, yes. Do you know what it costs to legalize an ADU?
It's, no.
You don't know?
No, I think.
I don't either.
It's based on a thing, if we were just at the county, it's closer to 30,000.
30,000?
And then
Yeah.
it depends on the square footage of the ADU too.
Yeah.
Because it would go up in value. It's quite expensive.
Yeah.
It's not,
But it's probably cheaper than building one.
yeah, it's cheaper than building, but no, they do tax it. I think it was above,
Yeah.
it was close to 30,000. And that was the Arcadia,
Okay.
county.
I just have one question. I don't know, I'm in and out. So did you talk about when somebody does like the co-signing?
Oh, no, I didn't.
Can you bring that, because I know a lot of people have co-signing.
Okay. How many of you have sold a home where the buyers were like a young couple and couldn't qualify for a loan on their own? Michelle, how many of you actually processed? So they need a co-signer, and oftentimes who is the co-signer? The parents. So the parents get added to title, sometimes, not always, but they'll go on title and on the loan as a co-signer. 3, 5, 8 years later, the children become more established and they go ahead and refinance and they take parents off title. Pre-Prop 19, they go ahead and check the P-Corps saying, oh, it's a parent-child exclusion. The assessor would send out the parent-child exclusion claim form and they fill it out and they'd go ahead and allow it. Now, because the parents have to actually live in the home, that doesn't qualify for parent-child exclusion. They should be checking the box that says removal of a cosigner. Oh, yeah. Also, before they close escrow, they should file, or they should create a document between the parents and the children, or siblings, or whoever's co-signing for them, and go ahead and basically sign a contract saying that, you know, we're just going on title as co-signers. We have no beneficial interest in the property. That way, you can give that document to the assessor and say, look, they were just there as co-signers. The assessor go, okay, we won't reassess you. I had a situation that just got resolved recently, and I've got about 6 cases like this right now. I'll give you 2 examples. Gentleman was moving out of the country. So he wanted his sister to start making decisions for him while he was gone. So he transferred title to his sister. But before he did, he went to an attorney to find out if he could. So the attorney created a deed transferring the property from the man to his sister. And then he also created a deed that they did not record going from the sister back to the man. And they were going to record it someday in the future. They also created what's called a holding agreement. The holding agreement was basically saying that the sister didn't own the property. She's just going on title to help her brother while he's out of the country. And they were done. The assessor reassessed the property. LA County. And they went to the county and said, no, we have a holding agreement, blah, blah, blah. And they said, we don't care. Doesn't matter. There's a change of ownership. Title changed. They went ahead and fought the valuation and got the valuation reduced, but still their taxes went up about $2,500 a year. And from 2003 to 2023, when he first contacted me, 20 years went by, his taxes are now $3,500 a year more than what they should have been. Well, he called me because the sister died and he wanted to put title back into his own name. What are you laughing about? So he wants to put title back into his name, but he doesn't want to get reassessed, and he wants to help keep the value down when he gets reassessed. And I'm looking at his documents. I said, well, why were you reassessed? You've always owned the property. It was just a holding agreement involved here. Well, that's what I told the assessor way back then. But they said that they had to reassess. So I went and spoke to the assessor, and I'd done it many times before. And they say, well, we have no way to track it. Open up the R&T code and I say, okay, show me in here where it says if they're subject to a holding agreement that the assessor does not reassess the property unless they have no way to track it. The R&T code says if it's a financial arrangement or a holding agreement that it's not reassessable. Show me why you didn't go ahead and keep the old value. We have no way to track it. Well, I got it reversed. I got the sale in 2000, or the transfer in 2003 reversed. It took 1.5 years, but he only got 4 years worth of refunds.
I was wondering, in that example, couldn't he just give her the power of attorney and not do all the deed transfer back and forth?
I think there was more to it. Oftentimes people would do that when they got somebody, a creditor chasing after them, but, you know. But he probably could have. But I'm not an attorney, so I don't know. The other example is a gentleman got divorced. They had a 6-unit apartment complex, and in the divorce settlement, he got to keep it, but he had to buy out his wife. So he had to give 50% of the value to his wife. He didn't have the cash, so he had to go get a loan. The lender wanted a cosigner, so he added his son to title and to the deed of trust. 50% reassessment because it went from husband and wife to husband and son. So 50% got reassessed. So my argument was, well, wait a minute, he is, you know, the full beneficial owner, son is only the cosigner. And when he first called me, we're talking about it, I said, well, okay, you added, he said, I got reassessed and I don't know why. I said, well, you added your son to title. He goes, I didn't add my son to title. So I sent him a copy of the deed through the email. I said, well, is that your son on title? Yeah, why is he on title? I said, well, it's probably financing purposes. What do you mean? Well, you got a loan and he co-signed the loan. He's not on my loan, so I sent him a copy of the deed of trust. Is that your son? Yeah. He didn't know his son was on the deed or on the deed of trust. Yeah. I got it reversed, you know, but it took another year also. I'm done.
Thank you.
My name is Dublas, and like Linda said, our firm focuses on personal injuries and probates. That's our bread and butter. We do a lot of estate planning. But estate planning, when I first opened my office, that's all I did, right? I just dropped off flyers at all the escrow offices, real estate offices, talked to everyone. And just really because in the Hispanic community, there's a lot of money, right? There's a lot of houses, there's a lot of businesses, and they don't ever do anything about it. Like in their mind, they want to leave their stuff to their kids, but they're not really sure like how that happens, and then you get problems, you know, interstate problems, transferring the asset problems. And so thankfully I've done really, really good with the trust, and I present it to a lot of realtors. A lot of the trust referrals that I get are through realtors, primarily because realtors are out there talking to everyone and marketing. And in reality, it helps, right? When you're door knocking or introducing to people to bring additional value to your services, right? Like if you explain to people what a trust is, give them a little bit of information, they're more likely to rely on you, call you for what they need, and eventually list or buy a house with you, right? So that's our contact information. We're located in Torrance, but I'll go anywhere. I mean, I've been all over the state of California, mostly like Southern California, Riverside, San Bernardino, LA County. But I've been up to San Joaquin, San Francisco, anywhere. All right. And that's our fax. I don't know why that number's on there. But today, you guys will get my card, my phone number, my direct line. I'm usually pretty available. If I'm in court or you know, I can't answer right away, just shoot me a text and I'll gladly try to help with anything. All right, so these are the topics that I'm going to be covering. Who needs an estate plan? What are the forms that go into an estate plan? And then probates and the changes that have come in probate, with some good changes for a lot of people. All right, so who needs an estate plan is everyone really, right? But it's so, you know, if you have complicated family affairs, you got children from a prior marriage, you have not married, but you want to leave something to other people, you have bad kids you want to exclude, right? Those are people who definitely need a trust. Also, if you receive Medi-Cal and Medicaid, I highly recommend, that's one of the main reasons you want to do a trust. And the reason why is if you if you have a trust, right, Medi-Cal will provide services. We never know what's going to happen to us. You know, it could be cancer, dementia, Alzheimer's, all kinds of stuff. Medi-Cal will cover it. In fact, they're not going to look at your assets. A lot of people are worried about, you know, is Medi-Cal going to find out if I have a house and all that? They don't really care about your house anymore. As of, I think as a year or two ago, they look at your income, right? What you make yearly. And based on that, you either qualify or you don't. But if you have a home, they'll cover your services. However, if you pass away and your house is not in a trust, they're going to come back and through probate, they'll get paid for all the services that they render, especially if it's something huge. If you get into a huge accident, I had a PI case, like you guys know, I do PI cases. Unfortunately, the woman passed away. Her medical bill from Medi-Cal was over $1 million. She didn't have a house, but imagine if you did have a house and that would have to go into probate, it would take the whole thing, right? I mean, you can probably negotiate that and deal with Medi-Cal, but it's something you don't want to do. You want to just be able to transfer to your kids and have them enjoy what you worked for its entire life. And obviously those with assets should always have a trust, primarily people with homes. And as Mr. Meyers mentioned, most people, the main asset that they have that they're passing over to their kids, it's real property, their primary home. All right, so there's 4 documents in an estate plan. There's the trust, there's the will, power of attorney, and the advanced medical directive. And I'll talk a little bit about those documents going forward. So starting with the trust, there's 2 types of trust, right? There's revocable trust, which means you can change your beneficiaries, your trustees, your successor trustees. You can sell your house, you can refinance your house, you can do whatever. You can change your kids, whatever you want. You can extinguish the trust, and 99% of the trusts that I do are all revocable. All right. You also have irrevocable trust. A lot of people refer to that as asset protection trust, and it sounds really good, except that it's fixed, right? You're not allowed to sell the house. You're not allowed to change the beneficiaries. You're not allowed to change the successor trustees. None of that. It's fixed. Technically, you live in the house belongs to you technically, but it belongs to your kids, right? So liability may still attach to your kids or those beneficiaries that you appoint on that trust. So those are done usually for people who know they're going to get sued. They're in businesses that carry a lot of liability. People always ask, like, so what do I do to protect my house? I always encourage people to get really good auto insurance, because that's most likely how they're going to come after you. If you run over someone and they die, then they're going to come after you. You can get what is a homestead, and then this also applies. LA County has $600,000 of exclusion of debt you can wipe out. It protects $600,000 of your equity, right? So there's that, but I always recommend people get really, really good auto insurance. The other document is the pour-over will, and this one is very, very important. And it works together with the trust, right? A lot of people, they always come to me and they'll say, like, hey, I know somebody who'll do a trust for $600 or $1,000. I'm like, yeah, but you don't know what you don't know. And they're likely getting only a trust or only a will. And the problem with that is that these documents work together. You don't know when you're going to need them. You may not need all of them at once, right, or at all. But what this pour-over will does, it captures anything that's left outside of the trust and brings it into the trust, kind of like a funnel. And a perfect example of this, I did a trust for a doctor, and he found out he was going to die soon. He got diagnosed with cancer, and so it unraveled really fast. So he did his trust, did everything, but at the same time, he refinanced his house, and the lender didn't put it back into the trust. And so, yeah, I know. And so that we used the will. It was a smaller probate. We still had to probate it, transfer it into the trust. But that's the stuff that happens, right? I mean, in his head, he had everything lined up. But he refinanced his house. He never told me. So his spouse called me and was like, hey, the house is not in the trust, and the bank is calling me. And so it's very unfortunate. The lender the lender's job is just to kind of finish the loan for you, right? But I believe as a courtesy, it should be brought back into the trust.
It should be within the escrow period too. too, right?
Yeah, escrow can take care of that.
Multiple eyes are on it.
Yeah, but it happens very, very often. Yeah.
So there's a different, there's a original will, and then there's something happen. You need to you want to write this forward will. But instead of write this new one or additional one, why don't you just, whatever you want to put addition, just put on the trust. Just write in the trust.
That's a good question. So the trust covers things that have title, like your bank account, your home. You can do life insurance, 401ks under your trust, right? The will is everything that doesn't have a title, like tangible items. Oddly enough, your cars go in the will too. But so this is like a catch-all, right? But this will works as a catch-all, but wills generally are for tangible items. So that's why you can't just identify something in the will. You can, right? But this has verbiage in it that's going to capture everything and transfer it into the trust. For example, it has verbiage in here, that if the trust is for some reason invalid, then the will kind of reinforces what's in your trust. And so the point of it is to uphold what your wishes are, right? It reinforces something. Like, think about it, if you have 3 bank accounts, you have Chase, Wells Fargo, and US Bank, and 2 of those are under the trust, and the third one is not, it's presumed that the third one was intended not to be in the trust, right? And then let's assume that in that third bank account, you have a lot of money. You have most of your savings in there, but accidentally just never put it into the trust. Well, then your heirs can use this pour-over will to bring it into the trust, especially if it's $1 million or if it's over a certain value, then that amount would go into probate. And I've done it where the house is into the trust, but a retirement account, like $1 million is not. And so we file what's called an 850 petition. It's a much faster probate. You still have to prove who the heirs are. You have to prove that the settlers and wanted that money to be distributed according to the trust. Yeah.
Sometimes within the bank account or 401k, there's a beneficiary. Would that help if you don't have a?
Yeah, and that helps. And so what also happens, I always tell people in your bank accounts, in your life insurance, in your 401ks, you can put your trust as a beneficiary, and it just works as a funnel to distribute to your heirs, right? Because what's happened is that, let's say you name 2 of your kids on your life insurance. One of those kids passes away, and then you pass away, but you never updated your life insurance beneficiaries. Now, the insurance company is going to want to issue a check to that deceased child, right? And life insurance proceeds are pretty big. So if that child had children, then those children have to petition for probate, right? And so it just kind of stops it there instead of issuing a check to your trust, and your trust goes into the bank account under the trust and then distributes accordingly. Yeah, exactly. Just put everything in the trust so that.
Very careful when you're building the trust, because as you said, like if it doesn't get stuck or
Exactly.
Is it true that beneficiary also like limited to certain amount of money? For example, if the account has like $2 million, but even you label your children as the beneficiaries, that they are limited to inherit certain amount. The rest is still subject to.
Not really. So you can tailor your trust to say that your kids get the entire benefit outright, or that they get it at increments, that they get it evenly. But if there's $2 million and your trust says give it to my kids, they're going to get the whole thing. There's no reason why they should get the whole thing.
So another lawyer will give you different information.
Could be. Maybe there were some other facts. Maybe there were some other facts that would have changed the outcome of that. Taxes, maybe. Yeah, I'm not too sure. But usually that it, like we attorneys like to say, it depends.
When does the pour-over will come into place? Is it once the trust has been established?
Yeah. So these two work together, and then it may not come into place because you may have everything into the trust, or let's say you have a wrongful death lawsuit. The will kicks in to appoint somebody to file that lawsuit on their behalf. Because usually on a wrongful death, you can either put all the heirs on the caption, or you can have somebody appointed to litigate on behalf of the estate, which would be under probate, but then the will kicks in and puts that person there. So, yeah.
So when you're using this pour over will, are both the trust and the pour over will going to basically say the same thing?
Yeah, this one mirrors the language to the trust.
The pour over will will just cover the things that might not be in the trust, right? But
Exactly.
You want both of them on.
Exactly. You always want both. Good.
What if some assets were established after the trust and the pour-over will were created? Does the pour-over will give a generalization, or we assume that those assets should go to?
Yes. Yeah, it's a cash. You mean like if you buy a house and just never put it into the trust and then you do your trust? Yeah, definitely. That's exactly the purpose of the pour-over will. Yeah, good.
So the question is, if we've established a will and trust and then the attorney is no longer in practice, can we move on to a new attorney?
Yes.
Add on?
Yeah.
Right, that's very important.
That's a really good question. And what we record in the county is just the grant deed saying that the house is under the trust. We don't record the trust. The trust is private. And I had a case too where we knew the house was under the trust, but we didn't have a copy of the trust. And the attorney had been disbarred or just no longer around. And the thing is, these issues don't come up for like 20 years, 30 years, And so obviously the attorney may not be there anymore. So yeah, you can go to any other attorney to finish off the trust. But what I do, I always send copies, emails to the clients and just tell them, keep this, make extra copies for yourself. Tell your kids where that trust is going to be at so that they can go and access it. Because a lot of people, it happens where the house gets ravaged, right? And people destroy documents and to try to, especially if they're excluded, right? So, go ahead.
Will you amend a trust that's been drafted by another attorney? I recently reached out to someone who would not do it and wanted to start over.
Usually it's recommended. It's probably easier too, depending on how big the change was. I've had it where the trust, so my old building when I used to be in Orange County, there was a lady who did trust for people and she just blew it all the time. The bar came in there looking for her because she had so many complaints. Yeah. And people, so many clients would just go in there complaining, my trust is wrong, this is bad, we don't know what to do. And so, those kind of trusts, I just tell people we just have to eliminate the whole thing and just redo it, right? If you're just changing a clause, that's pretty easy. It doesn't require that. But yeah, I'll be willing to work with you guys. There's another question around here. Yeah.
Do they have to keep the original copy? Sometimes some things happen and the original copy got lost.
You don't need a photocopy. Yeah, photocopy is fine. You don't need the original. Photocopy? Yeah. The other thing too. Like I said, there's different types of wills, right? What happens is somebody on their deathbed handwrites a will, and we'll get to that when we get to probate. If you only have a will, you end up in probate anyway, right? A lot of people don't think, they think that just a will is good enough, but it's not. You're going to end up in probate, and there's a lot of factual issues with that. There's capacity that comes into issue, and those get all litigated in probate. All right, so these are the other two documents. Sorry, go ahead.
So under what conditions would you suggest an amendment versus a restatement versus just redoing?
Yes, so an amendment would be if you're changing a clause, if you're changing a beneficiary, if you're changing a trustee, like a successor trustee. Let's say you put a family member as a successor trustee, but then that family member passes away. You just go in there and update it to take that person away. A restatement is completely redoing the trust. You just eliminate the whole thing. You never get rid of the old one though. The old one stays and you just put the new one on top to show the changes. So, and then if you're going to redo the whole thing, it's if you go through a divorce, right? If you want to, if it's just easier, like if you're changing the beneficiaries, the trustees, the way of distribution, everything, I'm like, hey, let's just do the whole thing. You know, just sit here and do it all at once.
Okay, so if you have a restatement done, you need the original as well? You need the original?
Right, or a photocopy, but you do need it. So
You need what it's restated, what the
Right.
restatement would be, right?
yeah,
So that's-
because in that restatement, we reference the old one that allows a restatement or amendment. Right? So you have in that new one, you have to identify the paragraph that allows you to change it. Because like I said, there's irrevocable as well. And if you don't have the consent of the beneficiaries on it, irrevocable, you're not going to be able to change it. These two documents are also part of the estate planning. It's a power of attorney and advanced healthcare directive. I highly, highly recommend people do these at a minimum. If people don't want to do a trust, they don't want to do a will, they don't want to do the whole thing, at a minimum, do these two. I have forms that I'm willing to give away for people. Obviously, the ones that I create are much more complicated, but I have very basic forms that will keep you out of conservatorship. These two forms keep you out of conservatorship. And so if you want templates or blank forms to give to your clients or a family member or for yourselves, I'll gladly provide them. Just give me a call and I'll email them to you guys. But if you don't have these, I get a lot of calls where people say, hey, my mom and dad, they're in the hospital, they're very sick, or they're starting to lose it. Can we just do a trust now? I'm like, no, I'm sorry. If they don't have the capacity to sign, we're not going to be able to do a trust and power of attorney for them. You're going to have to go to court, get a conservatorship, and then create the trust. And I don't know conservatorship attorneys. I mean, I can find some, but they're very difficult to work with because it's expensive, right? And the people who need this stuff don't have the money to pay $400 or $500 an hour to go get a conservatorship. And it's a very lengthy process. There's investigators that go out there. You got to get doctors to review the medical condition and to provide their opinion that this person is really incapacitated. So I always recommend that people do these. Another one that's become very, very popular is the power of attorney at the moment due to the circumstances of the immigration. A lot of people are calling and saying that they want to make sure that their kids or somebody can make decisions on their behalf in the event that they're deported unexpectedly. And with this power of attorney, there's one that's, I wouldn't say basic, but the one you want for those circumstances deals exactly with real property. And then you record that power of attorney so that the person may act on their behalf if they get deported for whatever reason. So right now it's much necessary. So that was the estate planning portion of it. Now I'll go into probates and the new changes that have come into probates. And so Assembly Bill 2016 has changed things drastically, right? Because before this, if you had an estate valued under $184,000, right, and some change, it was a little bit more than that, you could avoid probate. You just sign an affidavit, and then they'll give you the money in the bank or whatever you need to do. You can just take care of it. If it was below that amount, if it was over that amount, you have to do a formal probate proceeding, which was publication, bond. In LA County, it takes about 1.5 years to get a probate completed. Even if it's uncontested, it takes a really long time. What this bill does, it allows to do a summary probate you still have to petition to the court, you have to get an appraiser. Now I'll go over these elements first, but it's a lot faster. You might be able to get it done like in 6 months to a year. And so it streamlines the process. Cost should be less, right? And these are the requirements. Date of death has to be after April 1st, 2025. So if anybody has passed before that, you're going to have to go through the regular probate proceedings. And then the other part is that no probate has been initiated. There's many circumstances, I can't think one off the top of my head, where somebody's going to want a petition for probate if all you have is your home for $750,000. But that's a requirement that there hasn't been any probate proceedings. The other one is 40 days have passed since the decedent's death. So you can't do this right away. You have to wait some time. And then determining succession of primary residence. So you have to determine who the beneficiaries are, identify the property, not the beneficiaries, sorry, you have to identify the heirs of the decedent. The property value has to be $750,000. It's not the value that you bought it at, but at the time of death, that value has to be under $750,000. Yes, sorry, I skipped that part. That's very important. It has to be your primary residence. So if a person has multiple properties, if you have multiple properties in another county, it's definitely going to be over $750,000 anyway. But if it's an investment property and they don't live in that property, you're going to have to go through probate. Yeah. Sure. Okay.
Is there a reason why you have to wait 40 days after the person passed away?
I don't know exactly. Maybe just give it time to give notice. The death certificate doesn't get issued right away anyway, so you may have to wait a little while, but that's just a rule. I don't question it, I just follow it. I don't know.
Use that condo to try to locate relatives or something that they go to?
Yeah, so usually the person who's going to be in charge of doing this proceeding has an obligation to find the heirs. You absolutely have to, because if you don't, they can reopen the probate and come after you for violation of your fiduciary duties.
I have a quick question. So is this in regards to just real property or personal assets all summed up together at $750, or just the personal money, just the real property?
Yeah, so this is applicable specifically for real property. The cash values, I haven't dealt with that yet, but the cash value is probably just $182,000 and some change still. But yeah, this is specifically for real property. Okay. The other one is must obtain court-approved appraisal. That's a probate referee who values the property. Do you have a question?
How much time do they have to notify the heirs?
Just one time. It's at the petition. I'm sorry?
The period of time, right?
Well, how long you have to wait? There's a statutory period that you have to file a notice on there. It's on the form, but yeah, you'll see it on the form there. And then it's usually 30 days though. Like regular probate, you have 30 days before the hearing to object. So whatever your hearing is, you have to object before that hearing. And in LA County, if you show up on the date of the hearing, the court will just continue it and give you an opportunity to file your objections or whatever it is. And so, all right, so the property value is $750. You must obtain a court approval appraisal. The probate referees are pretty conservative. They won't appraise the property really high, so you don't have to worry about that. But yeah, so there's that, and then you notify all heirs of the family. Okay, so this is the probate process. Like I mentioned, you have to determine if there's a will and whether the will is valid. The fact of whether it's valid or not gets litigated at length. So in probates?
Yeah, there's no trust, but there's.
Yeah, it helps a little bit. What I encounter most is the person's very, very sick, and then they create a will somehow, and then that will gets, it disinherits the wife, disinherits all the kids, and so I'm like, how legitimate is this? I don't think so. So that's a lot of, that's what happens at this first stage, right? Somebody wants to get that will admitted, and obviously the people who got disinherited want to cancel that will. And so canceling the will, you cancel it based on duress, capacity, not duly executed, those sort of things. And again, you have to determine who the beneficiaries are of the heirs. So, yeah.
For the will, you need it notarized, correct? Because you can't just write it and then just say this is valid. Right.
So no, a will doesn't have to be notarized.
It does not.
It does not. You can, yeah. It's encouraged to have it witnessed by 2 people, but even a will on a napkin can uphold. Yeah, there's certain things you have to do. You have to date it, sign it. You have to say who your name is. But even the witnesses is not required. Yeah. And, well, that would be a witness. That would be a witness. What is notarized is the trust, though. The trust is notarized, but not the will. When I do the will, we have witnesses in the office, so we sign it there. But
Don't you have to put something in the newspaper, a notice?
At publication, yeah. So if you're in probate, once you get appointed, or before that, you call the newspaper, say we need to publish this petition, and they'll publish it for a month or 4 weeks, and then that's one of the requirements before you get appointed. And then, so you have to determine the heirs. Surprisingly, there's companies out there who will find out. Oh, sorry, you have a question?
Would the probate only happen if the kids need more than the heirs to sell the property? If you don't sell the property, then you don't need to do probate.
You mean leave it in the trust or in the person's name?
Yeah. Well, why do you need to do probate just because there's no trust, right?
Correct.
There's no need to do probate.
Yeah, if you have a trust, there's no probate. But if
You only need to do probate if the kids or whoever is supposed to handle the property wants to sell the property. If you don't need to sell the property, you don't need to probate.
Well, you can't leave it in the decedent's name. I mean, I suppose you can, but you're not supposed to, right? Technically, you can stay in the decedent's name for years, but eventually someone's going to have to go to probate to transfer it out, and it just gets messier and messier as the generations get bigger. But I have had that, though. Yeah. Yeah, you always have to petition for probate. Step 3 is the appointment. You petition to be appointed as the administrator. A lot of dispute goes into that part of the probate process because the administrator gets to charge a fee, gets to charge hourly if they have to clean up the house, have to do sort of things for the estate. They also get to select a realtor, right, who sells the house. So a lot of benefits come from being appointed. Get to manage certain things. A lot of self-dealing happens with a lot of administrators. I've seen it where the property was like, they bought it in 2014 for $300,000 and they're trying to sell it now for $300,000. Like, you can't do that. But yeah, a lot of power comes with being appointed as the administrator. Thereafter, you sell the property, and the administrator has to get a bond, right? Because after you sell the property, all that money goes into the administrator's account. Technically, that person can run away with all the cash, right? And that's why they have to get a bond and insurance to ensure that they don't do so, and if they do that the beneficiary is going to be covered. And that bond usually goes about $2,500 to about $5,000 a year. So it's just more costs added to the probate. All right, and then the reporting accounting, that goes at the end. And so you take all the costs of the estate, probate, and then distributions. Attorney's fees are included in there. If any litigation was had, then you have to include it and deduct it from that. So it's a very long process. I've like I said, mostly it's about 1.5 years if it's uncontested. If it's contested, it can be 2-3 years before anything gets distributed.
How do you think that things distribute, like taxes go to first and then, lawyers or attorneys and that?
Yeah, so the order of priority, you mean, for paying? Usually there's enough money to pay everyone, right? But if there is no equity in the property, I wouldn't take the case. But yeah, taxes obviously always go first. Attorneys have priority as well. The administrator gets a percentage of the property as well, just for being the administrator. So, all right. All right, so these are some of the things that people do to avoid doing an estate plan, and then that create problems when you're in probate. So a lot of people add their children to title to avoid it. They're like, well, my kid's gonna get the house. And so that is the worst thing anyone can do. Because once they're on title, even if it's 1%, they can force the sale of the house. They can eventually, if they get they get in trouble and some liability attaches to them, they can go after the property. At that point, some people only create a trust or only create a will, and that's dangerous because, like I said, they work together. You may need all of them. You may need only the trust, but you don't know what's going to happen in the future. So I always recommend people to do the whole thing at once. My firm charges $2,000 flat rate for a trust, which is very, very, very competitive compared to other attorneys. But so there's no reason why people shouldn't just do it. And it's for their benefits. But yeah.
I still recommend every 5 years to kind of revisit and make sure everything's, and then make updates, because that's what I did for my 10 years ago.
Yeah, definitely have it reviewed. If you buy a new property, get it put into that new trust. If you're having doubts of how to distribute it, get it reviewed by an attorney.
And what's the fee for
Yeah. So I don't charge a fee to review trust.
revise it?
To revise it, if it's a fast change, like a small cost, you want to change maybe like $500. So not too bad.
Somebody is just putting like one property and versus someone who has like 10 properties.
Oh yeah. So it's $2,000 flat rate. It includes the first house, and then $350 for every house after that. Yeah. I'm sorry. $350 for every house after the first one. So if you have two houses, it's $2,000 plus $350, so $2,350. Yeah, so the flat rate for the trust is $2,000, and then $350 for every property after that, after the first one.
So for one property,
$2,000.
$2,000. 2,000. Oh, 2,000 is the flat rate.
Mhm.
Each property
$350.
So the first, can you explain? I don't remember. I think this would be a trust attorney question.
Uh-huh.
If you have a property in a trust and it's held community property, the wife dies and the husband dies 5 years later, or sells 5 years later, say he doesn't die, does he only get half of the step-up basis when she passes, or does he get the full step-up basis, the market value at the time of death?
I would let Mr. Meyers answer that part of it. As far as like reassessment, you mean, or taxes?
Correct. Yeah, maybe this is a CPA question.
Yeah. So I mean, there is you're in the trust. There's language where you can give income to the surviving spouse to avoid certain taxes, or where there's discretion where you can take the full amount, get the full benefit, and then obviously there would be penalizing. But there's also, you can do in the trust is that the half of the decedent spouse gets frozen, so it could pass over to the kids. In that event, you don't get the step-up basis, right? And the surviving spouse keeps theirs. But if the surviving spouse gives discretion to access the entire thing, I think that's when you get that step-up basis penalty or whatnot. Does that make sense?
Determine how the trust is written.
Yes.
When the spouse dies, whether the surviving spouse will get the full step-up basis or not.
That's correct, yeah. So, because you can make it to where the surviving spouse gets frozen, and obviously if it's frozen, the surviving spouse shouldn't get penalized for that. Should not.
Just a question. Now, with those fees for the trust, what additional fees for the 401 would there be?
There's no additional fee. That's the whole thing.
Included.
Yeah,
So that includes both.
all documents.
Okay.
Mhm. Somebody else have a question? Yeah.
for trust, you obviously need a lawyer. But for will, can you write it yourself? You have any piece of paper, create your own, any form, type, or if you need also a lawyer or better.
Yeah, you can definitely do a trust yourself. I mean, not a trust, a will yourself. It's not recommended, because like I said, you need witnesses, you need to meet certain requirements to make it valid, even if it is just on a napkin. So yeah, I wouldn't recommend it, but yeah, you can do it.
So then you better also do with the same lawyer the will.
Yeah. Well, if you come to me, I would do the whole thing.
Yeah. And the cost is the same?
Yeah. Yeah, the 4 documents. So those 4 documents, it's $2,000. Okay. Do you have a question?
So I know when you're going through probate and all you have is a will, it's much more costly because the state takes a substantial amount. So do you always, when you consult your clients, do you always suggest a trust and maybe a will if they want to add a will? Because the state is going to recognize a trust more than a will, correct? And then you're avoiding probate, so you're
Right.
charging all these fees.
Exactly. So when I do the estate planning, I just do the whole package. If somebody tells me I just want to do a will, I'm like, I'm not going to do that for you. It's kind of, if you're in my office and you want to do just a will and I do just a will for you, that's kind of malpractice on my end, because unless I tell you you're going to go to probate, right, you're going to have all these costs anyway. But I'd rather not. I mean, I'd rather just do the whole thing, because if you only have the will, like you said, you go to probate and it's costly. If you have the trust, it goes directly to your kids. You avoid all those fees. Yeah. Let me go. Sorry? So a probate, it goes by a percentage. And so on average, let's say the property's worth $750, which is kind of the average. It would be about $15,000 to $20,000 just in attorney's fees. So, but if you combine all the fees, it's probably about $40,000 to $50,000. And then that's the thing. A lot of people, I forgot to mention this. People think that they're going to be able to keep the house in a probate. Like, no, you're not. Because especially if you have more kids, right? Like, you're going to have to find a bank to finance it. I don't know any, but maybe you guys are in the business, you do. But the person has to qualify. They have to pay out the beneficiaries or the other heirs, pay attorney's fees, pay all. It's really hard to be able to keep the house. Good.
I know some friends, they don't have trust, but they do put their kids' name. They went to the county or city. I can't remember which department. Anyway, they wrote there the documents with their kid's name as beneficiary, like in a bank.
It's a paid upon death transfer.
Yeah.
So it's a document you record with the county. Do you have a question? Oh yeah.
How long does probate take?
Yeah, it's about a year and a half. Assuming it's uncontested.
That's something to consider on your parent-child exclusion issues. If one of the children cannot move into the house during the probate period, the year will lapse.
Wow. There you go.
And you can't
so,
live in the house.
right. So to answer your question, it's paid upon death document. You don't, there's some requirements. You got to record that document 6 months before your death. So you can't do it on your deathbed because it's got to be recorded for 6 months. And then, so if you record it 3 months later, you pass away, it's not valid. Does that make sense?
Why would someone use that for instead of going through it? It has to be recorded 6 months.
Yeah. They want to avoid the trust, really. But it's like a 2-pager. You record it has to be with the county for 6 months before you pass away. So You can't do it immediately before passing.
You mean this TOT, this document, only valid for like 6 months?
No, it just has to be recorded 6 months before you pass away.
That's why you said when mom and dad are in the hospital and they're dying, you can.
Right. Well, that was the competency issue. If they're in the hospital and they're not competent, then you can't help them.
So after 6 months, you can report this TOD, but then you don't need to do the probate.
Correct.
Yeah.
Correct. Yeah. Do you have a question back there?
My client died like 2 years ago, and then the second one, and then two kids are minor. It's like not over 21.
Uh-huh.
So he's trying to do the probate to sell her house, right? So the parent wants to sell the house. But there's no will, no trust.
So they have to go through the probate process. And at the end of the probate process, once you decide how much those kids are going to get, that money goes into a blocked account. So it's a second procedure you have to do. To petition the court to be appointed, yes. But to receive money, no. It just goes into a blocked account if they're a minor. You said that there's 2 minors, right? Underage? Yeah, so somebody who's not them, somebody's going to have to petition to be appointed as administrator. That person handles the entire probate, determines how much those kids are going to get, and then once they're ready to issue the checks, that you do a second process where that money's going to go into a blocked account, and who's going to be in charge of that? We're not in charge, but who's going to open that account for them, right? Yeah, you just got to find somebody who's going to be the administrator, or a probate administrator. I'm sorry? Oh, yeah. So guardianship is different. You don't need a guardianship for that. Guardianship is totally different from the money going into a blocked account.